listen-only mode.
Hello, everyone, and welcome to this month's webinar on identity theft in the workplace, what every employer needs to know. This free webinar is available exclusively for our compliance management subscription customers. I'm Robert Leland, the Director of Research and Product Development for Personnel Concepts, and I'm joined by my co-moderator, Kim Gabanting, who is our managing editor.
Hello, everyone. Today's speaker is Jessica Filio, who is currently the Associate General Counsel and Corporate Compliance Director at Indiana Farm Bureau Insurance in Indianapolis, Indiana. In her legal role, Jessica oversees the Corporate Compliance Department, resolves complex legal and regulatory issues, and offers pragmatic legal advice to senior management and corporate advisory committees to conceptualize, prioritize, and implement corporate strategic plans that secure data and avoid unreasonable risk. She's a graduate of the University of Wisconsin in Madison with a BA in psychology, and she received her Juris Doctorate from Marquette University Law School. Jessica is admitted to Wisconsin and Indiana state bars and the federal courts for the Eastern and Western Districts of Wisconsin and the Southern District of Indiana. Thank you, Jessica, for joining us today as our guest speaker.
Thank you, Kim, for having me.
Now, we initially selected workplace identity theft as our focus topic due to recent guidance issued by the FTC on cybersecurity for businesses, as well as recent high-profile security breaches affecting Ashley Madison, Sony, and Target. The format for today's webinar is a series of questions we'll be asking Jessica about how to prevent identity theft in the workplace and how to secure other sensitive data pertaining to customers and employees.
Now, before we begin, I want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also pose questions in the chat window. Most questions will be saved for the end of today's session, but those that are relevant to the subtopic being discussed will be posed where appropriate. At the end of the session, you will have an opportunity to use the Raise Hand feature in GoToWebinar to pose a question directly to our guest speaker. With that, let's get started with today's presentation.
Okay, Jessica, our first question concerns the threat of data breaches. Many of our customers are very small businesses who may not recognize the importance of having a cybersecurity and identity theft prevention program. Why should businesses act now to address these issues?
Over the last several years, there's been a steady stream of high-profile data breaches that have made headlines, with massive breaches as some of America's largest banks and retailers, which compromise the information of millions of consumers and employees. Other prominent breaches have achieved notoriety less for their identity theft risk than for their, juicy revelations. For example, there was the November 2014 hack at Sony Pictures that exposed the studio's communications about ongoing film projects, and then there was the hack of adultery promoting website Ashley Madison, which seems to have been motivated more by naming and shaming their 32 million users than stealing their personal information. While breaches at small and mid-sized businesses may receive less publicity, they pose just as distinct a threat. Regardless of size or industry, companies are vulnerable to lawsuits and enforcement actions, and even more certainly to distress and distraction if they fail to observe best practices in safeguarding sensitive data. So frustratingly, for businesses, legislation surrounding data privacy and information security issues has developed into a tangled thicket. Regulation keeps springing up, even though the area would benefit from some trimming and clearing. And at the federal level, there are a variety of laws regulating specific industries, most primarily the financial services and healthcare industries, as well as some blunter tools such as Federal Trade Commission authority to prosecute unfair and deceptive practices. Even more legislative action has occurred at the state level, which nearly every state regulating elements of data security and breach reporting. Accordingly, businesses that operate regionally or nationally, they need to become generally acquainted not only with federal law, but also with the near constant growth of state laws. So, given the sheer volume of legislation, most businesses should focus more on observing fundamental principles than on keeping track of every individual bill governing data privacy or data security. This webinar is intended to provide an overview of a business's legal responsibilities in terms of protecting personal information and preventing identity theft. With a particular focus on businesses as employers, the goal is to identify key sources of legal risk and then to provide general guidance on how to avoid liability.
Jessica, what types of information do businesses need to protect as part of a cybersecurity plan or an identity theft prevention plan?
So identity theft in basic terms involves the fraudulent acquisition and use of another person's or another individual's personally identifiable information. And we sometimes call personally identifiable information PII. So I'll call it PII. And of course, the definition of PII varies by statute, but PII may include address, phone number, social security number, as well as financial information such as credit card numbers. So regardless of the industry, almost all businesses handle some amount of PII. Companies operating in the financial services or healthcare industries are regulated extensively and should already be especially attuned to safeguarding privacy and confidential information, including PII. This webinar is oriented more generally toward companies operating outside of those regulated industries. In developing a data security strategy, an employer should first consider the categories of PII that it collects or handles. Broadly, these categories include 1, information on employees, generally stored for HR or payroll purposes. 2, information on customers, vendors, and other third parties. And then 3, sensitive information concerning the business itself, such as identifying information about the business, trade secrets, trade dress. For purposes of any particular statute, it may not matter whether the PII belongs to an employee or to a customer. In adopting a sound identity theft prevention plan, however, it can be useful for an employer to take inventory of the various types of sensitive information it collects, how the information is collected and stored, and who has access to that information. One important element in data security is restricting access to PII on a need-to-know basis. And then that need to know is the buzzword and the terminology that's often used. For instance, while a company's controller and its HR manager both may need access to some PII, the specific parameters will vary by position. While this inventory-taking process may seem elementary, the objective is to be systematic in understanding what categories of information the business handles, who in the business handles them, and then what specific legal requirements apply to those various categories of information.
So given the risks associated with personally identifiable information, what should every business do to secure employee data as required by various laws?
The most universal vulnerability for smaller businesses, I would say, involves the personal information of itself as an entity and of its employees individually. For hiring and payroll purposes, companies collect sensitive employee information, including social security numbers, which can be used to commit identity theft if the information is digitally hacked or falls into the wrong hands. Companies first need to ensure that they comply with laws restricting what information they can properly request and collect. While beyond the scope of this webinar, there are a variety of federal, state, and even local laws addressing what information an employer may request and use it in the employment complex. For example, in New York City, a local law went into effect in September 2015 that prohibits employers from requesting or obtaining an individual's credit history in all but the most limited circumstances. Now, apart from potential identity theft issues down the road, merely collecting certain kinds of personal information from a future or current employee may constitute a statutory violation. Setting aside credit history, employers must take appropriate measures to safeguard employee records that contain any PII, whether that information is stored in paper or digital form. Regardless of where a company operates, it should exercise certain best practices in terms of limiting access to sensitive information. Records reflecting Social Security numbers and other financial information, such as bank routing numbers or automatic deposit information, that should be accessible only by personnel who have a direct need for that information and should be kept under lock and key, both physically and digitally. This means, at a minimum, ensuring that any paper records are secured in a safe place and that access to records is password protected with robust passwords, as well as in some cases two-factor authentication, and that computer systems are appropriately secured. Beyond observing best practices, I would say that companies should be aware that a number of states have enacted their own laws prescribing how sensitive data or PII is stored and protected.
Can you provide an example of a state-specific law addressing the storage and protection of PII?
Yeah, well, there are 50 of them, but the two that really stick out in my mind are California and Massachusetts. So in California, it requires that organizations provide reasonable security in handling PII. And I believe it's Civil Code 1798.81. And in that, it says a business must take all reasonable steps to dispose or arrange for the disposal of customer records within its custody or control containing personal information when the records are no longer to be retained by the business by shredding, erasing, or otherwise modifying the personal information in those records to make it unreadable or undecipherable. The personal information covered by the statute includes a California resident's first name or initial and last name in combination with Social Security number, driver's license number, account number, credit or debit card number, in combination with required password or access code unless the data elements are encrypted or redacted. Not every company serves or employs California residents, and I know that, so those states are not unique in legislating how PII, particularly Social Security numbers, should be protected. Businesses everywhere really need to familiarize themselves with the laws of the states where they conduct business and employ personnel. It should already be a best practice, for instance, but companies never should include more than the final 4 digits of an employee's Social Security number on a pay stub. Some laws, such as Section 226 of California's Labor Code, explicitly require that Social Security numbers be truncated. Companies need to take care in redacting or encrypting sensitive information whenever and destroying old records in a manner that ensures that confidential information cannot be accessed. So just to cite one example, a Massachusetts hospital agreed to pay $750,000 in fines after it shipped computer files off-site to be erased without ensuring that the contractor had sufficient measures in place to ensure the confidentiality of the files. And while that also invokes some HIPAA requirements that are, related to the healthcare confidentiality, it's still a really good lesson to know that there are some really large fines involved. Robert?
So we mentioned earlier that the Federal Trade Commission has offered some guidance to businesses on how to prevent identity theft. What steps does the FTC specifically recommend?
Well, the FTC has issued a 5-step guideline for identity theft prevention and a 10-step process for cybersecurity. So I'll start with the 5-step guidelines relating to personally identifiable information. Step 1 is take stock. Know what personal information you have in your files and on your computers. Understanding what data is stored electronically and what data is stored physically can help you determine the right strategy for protecting that information. The next step is scale down. Keep only what you need for your business. Limiting stored information to what's absolutely necessary from an operational and legal standpoint will make that information easier to protect. Step 3, lock it. Protect the information that you keep by using physical, technical, and administrative safeguards and controls. For physical files, keep those cabinets locked and control who has access. Similarly, for electronic data, limit access and require passwords. Number 4, pitch it. Properly dispose of what you no longer need. While certain records must be retained for various lengths of time under various record-keeping laws, that does not mean that information can never be discarded. Make sure you purge your physical and electronic files once required retention periods expire. And lastly, plan ahead. I can't even say this enough. Plan ahead. Create a plan to respond to security incidents. This should include corrective actions, contingency actions, who will be notified, and the timing of that notification. And then, after you plan ahead, practice the plan that you put in place.
So, Jessica, in addition to protecting the personal information of employees, what laws pertain to the protection of credit and financial information?
Employee records are a prime target for identity theft, and companies can be liable under a variety of statutes as well as common law negligence if they fail to adequately secure access to those records. Businesses also must protect the sensitive information collected from vendors, customers, and clients. Perhaps the most typical security breach scenario involves the release of customer information, either through an internal threat or an external hack of insecure computer systems. Liability may arise on a variety of statutory and common law grounds, and this section highlights some of the key areas of concern. Any business that offers credit transactions must comply with the Federal Fair and Accurate Transactions Act, sometimes called FACT Act, sometimes called FACTA, F-A-C-T-A. I'll call it FACTA. Now, FACTA was amended and amended the Fair Credit Reporting Act by adding requirements intended to prevent identity theft and provide assistance to victims of identity theft.
What are the major provisions or requirements of FACTA?
One critical provision for businesses is FACTA's truncation requirement for credit and debit card transactions. Companies that accept credit or debit cards may not print more than the last 5 digits of a credit or debit card number or print the expiration date on any electronically printed receipt given to the cardholder. Businesses that even inadvertently print out a cardholder's entire account number or card expiration date may face class action litigation. Willful violations trigger a per violation penalty that, when multiplied, can reach crushing amounts. In addition to FACTA's truncation requirement, which applies to any credit or debit card transaction, companies may also have to comply with the statute's red flag rules. These provisions require certain kinds of creditors to institute programs to detect and respond to identity theft threats. For the most part, the red flag rules are directed toward financial institutions that are separately regulated, as well as insurance companies. Companies would be financial institutions, health care organizations, life insurance companies, and all of them will need to seek counsel to ensure that they're complying with these really specific rules. FACTA's red flag requirements, however, they also apply to creditors, and businesses should assess their credit practices to determine whether they fall under the statute.
So how does a business determine if they're considered a creditor under the FACTA red flag rules?
The Federal Trade Commission, or the FTC, has set forth some basic questions a business would consider in determining whether it is a creditor. And here they are. So you would ask yourself, do you defer payments for goods and services or bill customers? Do you grant or arrange credit? Do you participate in the decision to extend, renew, or set the terms of credit? Simply allowing customers to use credit cards or billing for services, for example, monthly billing, that does not trigger creditor status. But companies that regularly advance funds based on a determination of a customer's credit worthiness may be covered by the statute's red flag rules. Companies engaging in these credit practices must adopt a program to identify potentially fraudulent activity. A program must include reasonable policies and procedures to identify suspicious patterns or practices or specific suspicious activities. The program should include procedures to detect fraud, such as fake IDs or suspicious address changes, and set forth clear policies for appropriate actions to respond to red flag activities, such as notifying the customer or potentially law enforcement, and definitely reporting it up through your chain of command to the compliance officer and person who then would be responsible for telling governmental agencies. Companies must also update the program periodically to ensure that the program stays current and responsive to emerging new threats. Many smaller businesses do not engage in operations that trigger FACTA's requirements. But regardless of size or industry, business should evaluate their practices and take measures to detect fraudulent activity. And using some of the provisions and guidelines set by the red flag rules is really helpful for these other businesses to incorporate the practices, because a blind eye can equal negligence and potentially lawsuits or enforcement actions.
Now, what is a FACTA disposal rule, and who does that apply to?
Any business or individual who uses a consumer report for a business purpose is subject to the requirement of the FACTA disposal rule. The rule requires the proper disposal of information in consumer reports and records to protect against unauthorized access to or use of the information. The Federal Trade Commission, which is the nation's consumer protection agency, enforces the disposal rule. The Federal Trade Commission, or FTC, according to them, says that the standard for the proper disposal of information derived from a consumer report is flexible, and it allows the organizations and individuals covered by the rule to determine what measures are reasonable based on the sensitivity of the information, the costs and benefits of different disposal methods, and changes in technology. Although the disposal rule applies to consumer reports and the information derived from consumer reports, the FTC encourages those who dispose of any records containing a consumer's personal or financial information to take similar protective measures. The disposal rule applies to people who both large and small organizations that use consumer reports. Among those who would comply with the rule are, of course, consumer reporting agencies, and then lenders, insurers, employers, landlords, government agencies, mortgage brokers, automobile dealers, attorneys, or private investigators, then debt collectors, and individuals who obtain a credit report on prospective nannies, contractors, or tenants. And in addition, also entities that maintain information in consumer reports as part of their role as service providers to other organizations. So all these types of entities are covered by the rule.
What documents are covered under the disposal rule, and what is quote-unquote proper disposal?
The disposal rule applies to consumer reports or information derived from consumer reports. The Fair Credit Reporting Act defines the term consumer report to include information obtained from a consumer reporting agency that is used or expected to be used in establishing a consumer's eligibility for credit, employment, or insurance, among other purposes. Credit reports and credit scores are consumer reports. So are reports businesses or individuals receive from consumer reporting agencies that have information relating to employment background, check writing history, insurance claims, residential or tenant history, or medical history. The disposal rule requires disposal practices that are reasonable and appropriate to prevent the unauthorized access to or use of information in a consumer report. For example, reasonable measures for disposing of consumer report information, they could include establishing and complying with policies to burn pulverized shred papers that contain the consumer report information so that they can't be read or reconstructed, or policies to destroy or erase electronic files or media containing the information so they cannot be read or reconstructed. And also, it's important to conduct due diligence and hire a document destruction contractor to dispose of materials specifically identified as consumer report information consistent with the rule. So the big thing is you just have to properly dispose of it by burning, shredding, pulverizing. Due diligence can include reviewing an independent audit of a disposal company's operations or its compliance with the rule, or obtaining information about the disposal company from several references, or requiring that the disposal company be certified by a recognized trade association, or reviewing and evaluating the disposal company's information security policies or procedures. Violations can be initiated within 2 years from discovery of the violation or 5 years from the actual date of violation. In addition to the severe penalties and fines that federal or state agencies can impose, companies charged with FACTA disposal rule noncompliance run the risk of negative publicity and irreparable damage to their corporate reputation.
Jessica, you've mentioned that FACTA amended the Fair Credit Reporting Act. For the benefit of our audience, can you recap what the Fair Credit Reporting Act is and what it requires of employers?
Sure. The Fair Credit Reporting Act is a federal law, and I'll just call it the FCRA, and it seeks to promote accuracy, fairness, and privacy of an individual's consumer report maintained by a consumer reporting agency. So the FCRA also functions as the national standard for employers who want to find out more about an applicant or current employee. The FCRA covers consumer reports. In addition to creditworthiness information, it covers information about a person's character, general reputation, personal characteristics, and mode of living. This is the type of information an employer generally seeks before making important decisions about an applicant or employee. Therefore, whether a credit check is included or not, an employment background check is a type of consumer report that is covered by the FCRA. The purpose of the FCRA is to ensure that reports used to make important decisions, such as those related to a person's employment or credit, are accurate. Additionally, privacy is a critical factor in protecting a consumer or potential employee's rights. The law limits who has legitimate access to employment background checks. These safeguards protect both the subject of the background check as well as the employer or business owner. For example, a report that erroneously shows a criminal conviction can ruin a career, at the same time rob a business of an employee or customer. The FCRA applies to all businesses that seek information which meets the definition of a consumer report on an applicant or current employee, and that information is compiled by a consumer reporting agency. The FCRA covers both written and oral information, and the FTC can sue for violations.
We have a few questions that have been submitted by our audience that we'll probably save for the end of the presentation. But next, we want to cover recent guidance from the FTC on cybersecurity. So we've discussed how FACTA and the FCRA are enforced by the Federal Trade Commission. Has the FTC issued any in-depth guidelines for businesses on cybersecurity specifically?
Yes, the FTC has published a 10-step approach to formulating an effective cybersecurity plan for businesses of any size. The first step is start with security. Factor it into the decision-making in every department of your business. Collecting and maintaining information just because is no longer a sound business strategy. Step 2 is control access to data sensibly. Once you've decided you have a legitimate business need to hold on to sensitive data, take reasonable steps to keep it secure. You'll want to keep it from the prying eyes of outsiders, of course, but what about your own employees? Not everyone on your staff needs unrestricted access to your network and the information stored on it. Put controls in place to make sure employees have access only on a need-to-know basis, whether the information is digital or stored in locked file cabinets. Next, require secure passwords and authentication. If you have personal information stored on your network, strong authentication procedures, including sensible passwords, password hygiene can help ensure that only authorized individuals can access the data. Insist on complex and unique passwords. So passwords like password and 1212, they are not much better than no password at all. And store passwords securely. Be sure not to store passwords in a file folder named passwords, because that can also be hacked and then all your passwords can be taken. Don't make it easy for interlopers to access passwords. Additionally, guard against brute force attacks by locking out users after a certain number of unsuccessful password attempts. And then finally, don't give anyone your password. So that's part of password security. The fourth step is store sensitive personal information securely and protect it during transmission. So it needs to be stored at rest and stored during transmission. So for many companies, storing sensitive data is a business necessity. And even if you take appropriate steps to secure your network, sometimes you have to send that data elsewhere. Use strong cryptography to secure confidential material during storage and transmission. The method will depend on the types of information your business collects, how you collect it, and how you process it. But make sure the people you designate to do that job understand how your company uses sensitive data and have the know-how to determine what's appropriate for each situation. Step 5 is to monitor and segment your network. When designing your network, consider using tools like firewalls to segment your network, thereby limiting access between computers on your network and between your computers and the internet. Many companies have segmented their payment information and payment card information to a much more secure area that only a couple of people have access to. Another useful safeguard, intrusion detection and prevention tools to monitor your network for malicious activity. So you segment your network and then you use intrusion detection. The next step is secure remote access to your network. Businesses don't just happen in the office. You know, a lot of business is happening all over now on mobile devices as well as remotely through home computers, logging into work stations. While a mobile workforce can increase productivity, it also can pose new security challenges. If you give employees, clients, or service providers remote access to your network, have you taken steps to secure those access points? Even your website is an access point to your network. Step number 7 is apply sound practices for new products. Let's say you have a great new app, an interactive website, or innovative software on the drawing board. Early in the development process, before you're really too deep into it and you're even just conceptualizing, think through how customers will likely use the product. If they'll be storing or sending sensitive information, is your product up to the task of handling that data securely? Make sure your developers address security. Test for vulnerabilities and ensure that all privacy and security features work. Next, validate the security measures of service providers. Keep a watchful eye on your service providers. For example, companies that you hire to process personal information collected from customers or to develop software applications. Before hiring someone, be candid about your security expectations. Take reasonable steps to select service providers able to implement appropriate security measures and monitor they monitor them to make sure that they're meeting your requirements. The ninth step is keep security current and address vulnerabilities. Securing your software networks isn't a one-and-done deal. It's an ongoing process that requires you to keep up your guard. If you use third-party software on your networks, or you include third-party software libraries in your applications, apply updates as they are issued. And number 10, secure physical media and devices. Network security is a critical consideration, but many of the same lessons apply to paperwork and physical media like hard drives, laptops, flash drives, and disks. Store sensitive files securely. Protect any devices that process personal information and dispose of sensitive data securely.
I just wanted to show a quick list of those 10 steps before we proceed. Jessica, what other legal requirements pertain to the employer's duty to protect consumer privacy and prevent security breaches?
Data privacy and security laws have proliferated over the last decade. There are literally hundreds of laws, particularly at the state level, touching on consumer privacy rights and data breach notification rules. Although the patchwork of laws in this area may seem intimidating and certainly lacking in clarity, companies can protect themselves by complying with the more concrete statutes, such as Social Security number and credit card number truncation requirements, and by generally practicing what they preach. The FTC plays a major role in enforcing data security standards through Section 5 of the FTC Act. The Act prohibits unfair and deceptive acts or practices in or affecting commerce. Similarly, states have specific laws relating to how data is stored and transferred and how breaches are reported. They also have consumer protection statutes prohibiting unfair or deceptive practices and acts that can be wielded against companies that fail to employ reasonable security measures. In these unfair practice cases, the FTC or the state attorney generals may claim that a company's security measures were not adequate or reasonable to protect a consumer's PII. The FTC has settled dozens of claims in the data security realm, but a recent federal appellate court decision gave judicial force to the agency's authority to prosecute every cybersecurity lapses. The decision involved claims against the Wyndham hotel chain after hackers broke into the company's computer systems on 3 separate occasions, stealing customers' personal and financial information. Wyndham refused to settle with the FTC, and the court concluded that the FTC could prosecute claims based on Wyndham's inadequate security measures and repeated failure to take corrective measures. The court did not, however, reach the merits of the FTC's claim to actually find Wyndham liable. Wyndham also asserted that it lacked fair notice that it could face civil liability under the FACT Act, but the court rejected that assertion. If there wasn't fair notice before, there is now. So that's a pretty harsh requirement. So what happened was Wyndham didn't have good security, and somebody hacked in and took 619,000 names and pieces of information over several occasions, and Wyndham said they didn't know they were supposed to have tighter security. And the FTC said, well, you're on notice, you know now. And the court said, yep, that's right. Well, this happened in 2007 and 2008, and it was just decided here in August of 2015. So I know justice doesn't move swiftly, but it did levy a pretty harsh requirement, which now makes us, the rest of us, believe that we really need to be aware of the requirements. So the decision, therefore, has put all companies on future notice that deficient security measures could constitute unfair and deceptive practices.
So, Jessica, given the Wyndham decision, what exactly must businesses do to avoid claims of negligence or deficient security measures?
It's important to recognize there is no cybersecurity gold standard for all companies to adopt. An enormous retailer like Target or a worldwide hotel chain like Wyndham should be expected to have a more complex and far more costly computer security system than a small company serving mostly local customers. All companies must put into place appropriate security systems and processes to safeguard the sensitive personal and financial information of its customers and employees. Many measures aren't especially costly, like storing paper records in places that are secure, like including offsite storage, or ensuring that passwords are robust, hard to guess, and changed regularly, limiting access to paper and electronic records on a need-to-know basis, and critically adopting clear privacy policies and ensuring that the company complies with its own policies. On that note, one way that even a small company can invite trouble is to overpromise in its own privacy policies, including the online privacy policy statement on the website. The FTC entered a settlement in April 2015 with a startup mobile tracking company, Nomi Technologies, for failing to adhere to the terms of its privacy policy. The small company had promised a consumer opt-out for its services, but didn't deliver on the promise. For all businesses, the lesson is that the FTC expects companies to take reasonable security measures and to provide the degree of security that customers will reasonably expect. If, for instance, a company represents that certain information will not be shared, then the company must honor that, even if the sharing is allowed by law.
Now, are there any federal laws that specifically pertain to what to do in the event of a data breach?
No, there is no all-inclusive federal data breach law, although HIPAA has specific requirements pertaining to data breaches for protected health information. But there have been quite a few efforts recently to enact an all-encompassing law that would preempt state law and standardize the protocols for reporting data breaches for all types of data, but none have come to fruition. Therefore, in the event of a suspected breach, companies must consult the laws of the states where consumers may be affected. While the states differ some in timing and method of breach reporting, the key is to respond immediately to any suspected breaches. The rash of high-profile breaches demonstrates that even companies with large technology teams and sophisticated computer systems can be compromised. Breaches may not be inevitable, but they occur, and the best defense is to be able to show that a company has been vigilant and responsive.
So, Jessica, based on everything that we've gone over today, do you have any final tips or recommendations for employers pertaining to both identity theft prevention and cybersecurity?
Yes. Navigating the dense thicket of privacy and information security laws, it can be daunting. I get that. But companies can take a variety of relatively simple measures to help prevent identity theft. So I'll tell you a couple tips. First, check for industry-specific requirements, including whether your business is covered by the FACTA red flag rules. Also, understand the scope of PII, or personally identifiable information, and monitor the laws of the state in which you operate. Also, focus on who in your business has access to PII and take measures from strong passwords to locked offices to limit access to that information. If employees use computers or mobile devices to access your computer system, make sure that the system is secure and avoid use of unlocked, like public Wi-Fi networks. Also, vet any third parties that are going to be providing services, like IT consultants, off-site storage providers, okay, before entrusting them with sensitive data. Also, develop systems for detecting vulnerabilities and potential breaches. And implement a data security awareness training program. Personal Concepts is developing a data security awareness training guidelines for small businesses, and that will be presented in the future. And then I would say the final thing is respond immediately to any data breaches and check local laws for reporting requirements.
Jessica, thank you so much for reviewing this information with us. Before we end the session, let's take a moment to answer some questions from our audience that were submitted during the presentation. Robert will ask the questions on behalf of our attendees.
So there's a couple of questions that were pretty technical, also a couple that I believe that we've answered with the presentation content. There was a question earlier that was a little technical, and it's from a user by the name of Randy, who asked about the minimum bit encryption on firewalls. Has there been any case law, Jessica, that you're aware of that specifies certain minimum requirements as it relates to firewalls?
So from what I know, and I have been paying attention to firewalls, because it used to be that if you just put up a firewall, everything was good, and then they could get through firewalls, and it turns out not all firewalls are that good. So there has not necessarily been in litigation that I have seen on firewall encryption, or but PCI, the PCI data security standards for credit card holders, does have a little more robust requirements for how you have to deal with segmenting your different aspects so that you keep firewalls and not commingle information or allow, when you get into one section, to go to the next.
Now, I do have a user by the name of Carlos Sanchez who has raised his hand. I'm going to try to unmute Carlos so he can ask his question directly.
All right.
Carlos? Carlos, you are unmuted. Do you have a question for Jessica? We'll give Carlos a moment to respond. Okay, unfortunately, I believe he might be on mute on his phone. Looking over these questions, Jessica, I don't see any more questions that are relevant to the identity theft and cybersecurity topic in general. Do you have any final thoughts about the presentation that we just gave to the businesses? Is there anything like a point of emphasis that you really think that you'd like the attendees to leave with today?
Well, we did talk a lot about some of the things that can be done in order to protect against data breach and to secure your data. And those were all really good things. And interestingly, this area of breaching security has grown so much in just the last year. If you think about, for example, how rudimentary it used to be, where hackers would try to get information by calling up on the telephone to see if an employee would give it, to now much more sophisticated phishing expeditions, as well as other types of ways to infiltrate systems and also to trick people. And that's the big thing, this trickery. I mean, we're still all working in our businesses, trying to keep the data secure, and people try to trick us. I mean, how often do you get an IRS phone call with some guy saying to you, oh, you have an IRS debt? Yeah, right. Well, you really don't. And they're just trying to authenticate your information. They got your name, they got your phone number, and they got your date of birth because you entered, a publisher's clearinghouse contest, and now they're trying to verify what information is real and how susceptible you are to give over information. And then there's the other big hack that's going on, where someone calls up and says they're from Dell and somebody's tried to come get into your computer system, and so they you have to give information, password information, and boom, now they're in and they take over your computer system, and they aren't anyone from Dell. Dell would never do that. So I guess that's the big takeaway. When something doesn't seem quite right, we have to really sit and think to ourselves, wait a minute, is this for real? And that helps to, common sense goes a long way in helping to secure the data.
Absolutely. I don't have any more questions from the audience at this time. Kim?
So this concludes today's webinar. Thank you everyone for attending today's presentation. We hope you found this information useful in understanding the various legal issues associated with background investigations and pre-employment screening practices. Thank you again to Jessica for being our guest panelist. We look forward to continuing to work with Jessica on future presentations. And to all of our attendees, thank you for choosing Personal Concepts as your provider of workplace compliance solutions. Have a good afternoon and a great week, everyone.